Last day in this office, 26 years, and it all fits in 11 boxes. The movers are coming at 4. The recorder is running because I promised myself I'd get this one on tape before I walked out. Case number 2007-CR 44112. State of Tennessee versus Darren Ray Mosler. Felony murder, aggravated burglary, theft over $10,000, reckless endangerment, 4 counts. Assigned to me off the rotation list by Judge Linda Hamblin, Division 5. Davidson County Criminal Court, Courtroom 5B. October 2007. I didn't want it. Not because of the charges. I'd handled worse. Because felony murder cases in Tennessee carry mandatory life without parole, and the facts were ugly. Mosler, 31, broke into a house on Gallatin Road while the owner, a 74-year-old retired postal worker named Eugene Driscoll, was asleep in his recliner. Driscoll woke up. His heart stopped. The medical examiner ruled acute myocardial infarction secondary to sudden physiological stress. The state's theory was simple, but for the burglary, Driscoll would still be alive. Felony murder. Proximate cause. Clean line from A to B, except it wasn't clean. Driscoll had a cardiac history that went back 11 years, 3 stents, an ejection fraction of 22%. His cardiologist had written a letter to his family 6 months earlier. I found it in Discovery, recommending hospice evaluation. The man was dying. Slowly, but he was dying. So I filed the motion in limine on count 4. For the record, a motion in limine is a pretrial motion. You're asking the judge to rule on the admissibility of evidence, or in this case, the legal sufficiency of a charge before the jury ever hears it. I filed on the grounds that the state could not establish proximate cause between Mosler's entry into the home and Driscoll's cardiac arrest. The temporal gap was the problem. Mosler entered through the kitchen window at approximately 2:15 a.m. The Ring doorbell camera on the neighbor's porch, the only exterior footage, showed him leaving through the back door at 2:31 a.m. Driscoll's body was found by his daughter at 7:40 a.m. The medical examiner placed time of death between 4 and 6 a.m. That's a minimum 90-minute gap between Mosler's departure and Driscoll's death. I argued Mosler couldn't have been the proximate cause of a cardiac event that occurred an hour and a half after he left the premises. The state's expert, a cardiologist from Vanderbilt, testified that acute physiological stress can trigger a delayed cardiac cascade. I cross-examined her for 40 minutes. She admitted she'd never published on delayed stress cardiomyopathy. She admitted the phrase delayed cardiac cascade didn't appear in any peer-reviewed literature she could cite. She admitted that Driscoll's ejection fraction of 22% meant his heart could have stopped while he was watching television. Judge Hamblin ruled from the bench. I remember the fluorescent light in 5B buzzing. It always buzzed, that one panel in the southeast corner, and the smell of the old carpet, that institutional tang of cleaning solution and dust that every courthouse in the South shares. She looked at the state's table. She looked at me. She said, "The court finds that the state has failed to establish a sufficient causal nexus between the alleged criminal conduct and the death of Mr. Driscoll. Count 4 is dismissed with prejudice and shall not be submitted to the jury." I wrote it down, yellow legal pad, the kind with the wide margins. I wrote her exact words. Then I drew a line under them. Double line. I always do that when I win a motion. It's a habit, not a superstition. I clicked my pen shut. I put the cap on. I looked at Mosler in the holding pen through the glass, and I thought, his exposure just dropped from life without parole to 15 to 25 years. That's a win. That's the best I was going to do for a man who broke into a dying man's house while he slept. I packed up my briefcase. The clasp stuck. It always stuck, that old Hartman my wife gave me when I passed the bar. I unstuck it. I walked out. I drove to the office. I sent an email to my partner, Ray Castillo, at 4:47 p.m. Subject line, Mosler, Count 4 update. I typed, if Hamblin grants the dismissal on Count 4 tomorrow, and I think she will, Mosler's exposure drops to 15 to 25 years. That's a win. I stopped, deleted tomorrow. Retyped, Hamblin granted the dismissal on Count 4 today. Changed the tense. Sent it, closed the laptop, went home. That was October 11th, a Thursday. The trial was set for the following Monday. Everything was fine. Trial started Monday, October 15th. 3 counts now. Aggravated burglary, theft, reckless endangerment. I'd already won the big one. The rest was damage control. Voir dire took a day and a half. Struck 4 for cause, used 3 peremptories. Ended up with 7 women, 5 men. 4-person was a woman named Sandra Kessler, mid-50s, worked in insurance claims processing. She had the look of someone who read documents for a living. I liked that. People who read documents don't rush. The state's case took 2 days. Fingerprints on the kitchen window frame. Mosler's prior burglary conviction from 2001. The Ring doorbell footage from next door. Grainy nighttime, but clear enough. They introduced the stolen items recovered from Mosler's apartment. A Zenith tube television worth maybe $40, a jewelry box containing a woman's wedding ring, Driscoll's late wife's, and $1,100 in cash from a nightstand drawer. Mosler had been identified through a confidential informant who'd been in the apartment, seen the jewelry box, recognized it from a Facebook post by Driscoll's daughter asking for help finding her mother's ring. I didn't put on much of a defense. Didn't need to. The charges were solid. My closing focused on the reckless endangerment count. I argued that Mosler couldn't have known Driscoll was home, that the entry through the kitchen window was on the opposite side of the house from the bedroom, that there was no evidence of confrontation. It was thin, but it was something. Jury went out at 2:40 p.m. on Wednesday. I expected a quick verdict, maybe 2 hours. The charges weren't complicated. The evidence wasn't disputed. What I was hoping for was a question from the jury, a note asking about sentencing ranges, which would tell me they were thinking about proportionality. They deliberated for 4 hours and 22 minutes. No notes, no questions. They came back at 7:02 p.m. The bailiff called us in. I remember the courthouse was mostly empty by then. The hallway lights were on that automatic timer. Half of them had already switched off. Our footsteps echoed on the marble. The courtroom smelled like cold coffee, and that particular staleness that settles into a room where people have been arguing all day. The clerk handed me the verdict packet. I opened it. Standard practice. I always flip through the forms before the 4-person reads. I count them. 3 counts, 3 forms, except there were 4. I stopped. Count 1, aggravated burglary, guilty, 12 signatures. Count 2, theft of property over $10,000, guilty, 12 signatures. Count 3, reckless endangerment, guilty, 12 signatures. Count 4, felony murder, guilty, 12 signatures. I want to tell you I stood up. I want to tell you I said, Your Honor, there must be a mistake. Count 4 was dismissed with prejudice on October 11th. That's what I should have said. Any first-year public defender would have said it. It would have taken 3 seconds. I didn't say anything. The 4-person stood. Sandra Kessler, in the same gray cardigan she'd worn every day of trial. She read, On count 1, aggravated burglary, we the jury find the defendant guilty. On count 2, theft of property over $10,000, we the jury find the defendant guilty. On count 3, reckless endangerment, we the jury find the defendant guilty. She paused. She turned to the last page. On count 4, felony murder, we the jury find the defendant guilty. Nobody reacted. The prosecutor didn't react. The clerk didn't react. Judge Hamblin, the same judge who had dismissed count 4 6 days earlier, from that same bench in that same courtroom. She nodded. She said, "The court will now poll the jury." One by one. Juror number 1, is this your verdict? Yes, Your Honor. Juror number 2, all 12. Yes, 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 yes. I was sitting at the defense table. My yellow legal pad was open in front of me. I looked down at my notes from October 11th, the page where I'd written Judge Hamblin's exact words. Count 4 is dismissed with prejudice and shall not be submitted to the jury. The words were there, my handwriting, my pen. But the double line I'd drawn underneath them was gone. The page was smooth, no indentation, no ink, as if I'd never drawn it. I looked up. The bailiff was clearing the gallery. 10 minutes had passed. I don't remember those 10 minutes. I don't remember hearing the verdict accepted. I don't remember the judge setting a sentencing date. I remember the verdict being read, and then I remember looking at my notepad, and the room was empty except for the bailiff and me and the fluorescent light buzzing in the southeast corner. I filed the motion for a new trial the next morning. Rule 59 of the Tennessee Rules of Criminal Procedure. Grounds: the jury returned a verdict on a charge that had been dismissed with prejudice. I cited the court's own ruling. I drove it to the clerk's office myself, filed at 9:14 a.m., kept the receipt, then I pulled the court recording. Davidson County switched to digital court recording in 2006. FTR system, 4 ceiling-mounted microphones, time-stamped to the second, backed up to the county server nightly. I requested the October 11th hearing. The clerk had it to me by noon. I sat in my office, door closed, pressed play. The recording was 47 minutes long. My argument on proximate cause, exactly as I remembered it. The Vanderbilt doctor admitting she'd never published on the topic. Every question, every answer, precisely right. Then Judge Hamblin's ruling. Her voice. The same cadence, the same slight pause before she delivers a ruling. I've been in front of her for 9 years. She said, "The court finds that, while the causal connection is attenuated, the state has presented sufficient evidence to survive a directed verdict challenge. Count 4 will be submitted to the jury with appropriate limiting instructions." I rewound it, played it again. Not dismissed, not with prejudice, submitted, with instructions. The background noise was right. The buzzing fluorescent in the southeast corner, the one I remembered. The recording was real, but that is not what she said. I called the court reporter's office, requested the transcript. They emailed it within the hour. Page 14, lines 6 through 9. The court. Count 4 will be submitted to the jury with appropriate limiting instructions. The defense's motion in limine as to count 4 is denied. Denied. I looked at my yellow legal pad, October 11th. My handwriting. The same page I'd been staring at the night before when the bailiff cleared the gallery. It read 4, submitted were instructions per Judge Hamblin, motion denied. That is my handwriting. I know my handwriting. I've written on yellow legal pads every working day for 26 years. But that is not what I wrote on October 11th. I checked the email, the one I sent to Ray Castillo at 4:47 p.m. on October 11th. Subject line, Mosler, Count 4 update. I opened it. The body read, "Hamblin denied the motion on Count 4 today. She's submitting it to the jury with limiting instructions. Mosler's exposure stays at life without. Not what I wanted." The timestamp was correct, 4:47 p.m., October 11th, 2007. No edit history. The email had never been modified. I sat there for a long time. The coffee in my mug had gone cold, that sour, burnt vending machine taste coating the back of my throat. I withdrew the motion for a new trial. I had no grounds. Every document, every recording, every transcript confirmed that Count 4 was never dismissed. The only evidence that it had been dismissed was my memory, and my memory apparently was wrong. Darren Mosler was sentenced to life without parole on November 9th, 2007. I stood next to him at sentencing. He didn't look at me. He looked at the bench. He said one thing before they took him out. "You said it was gone. You told me it was gone." I didn't respond. The bailiff put his hand on Mosler's arm. The door buzzed. He was gone. I never told anyone. What would I say? That a judge dismissed a charge and then reality disagreed? That every document in the Davidson County court system contradicts what I saw, what I heard, what I wrote, and then rewrote itself to match? The recorder's still running. I kept one thing, the email. It's in my sent folder. I look at it sometimes. It still says what it says. That Hamblin denied the motion. That count 4 was submitted. That Mosler's exposure stayed at life without. But there's a detail. The subject line, Mosler count 4 update. I always write count with a capital C. Always. 26 years of legal correspondence. Capital C. The subject line says count. Capital C. But in the body of the email it says count. Lowercase. I never write it lowercase. Whoever changed that email wasn't careful enough. Or maybe they were exactly careful enough and they left it there on purpose. The movers are here. I should turn